Saga man fought the law and won. So this guy won a court challenge over a bylaw that required homeowners to keep the grass on their lawns under 20 centimeters in height. Wolf Ruck, solid name, says that he essentially completed a years-long postgraduate in law so he could go toe-to-toe with the city of Saga in a legal fight to preserve his naturalized garden. And just on January 6th, the Ontario Superior Court ruled in Ruck's favor, finding, get this, that the city's bylaw governing the length of grass infringed on his charter rights. Now, this battle first began in 2021 when a bylaw officer knocked on Ruck's door, informing him he had received complaints about his lawn and to cut everything down as the goldenrod he had planted was a health hazard. Ruck at this point educated the officer and told him that goldenrod is often mistaken for ragweed. In your face. Ruck is part of a natural gardening community, a group that puts a focus on bioecological function over pure aesthetic. I actually have a few people in my neighborhood who have lawns just like this here in Hamilton. And Ruck argued that his yard was a bird and wildlife sanctuary, adding the long grass served as food. Ruck went on to argue that his yard was a bird and wildlife sanctuary, adding that the long grass served as a food source for animals. And the bees. Don't forget the bees. Even still, he received more complaints from neighbors in the years that followed, and in 2023, the city arranged to mow his lawn and remove nuisance weeds. But Ruck did not comply. So the city paid a contractor $287.59 specifically and added the bill for the job onto Ruck's property taxes. But lo and behold, Superior Court Justice Michael Doy wrote, "In this case, I find the impact of the bylaw's tall grass and weed provisions on the right to freedom of expression is relatively serious. The provisions serve to restrict societal expression at the landowner's home." Who knew that weeds could be considered a form of personal expression? Let me know your thoughts below.